Hi, everybody. I'm Mike Sokolski here on Spotlight On. And my guest today is Professor Patrick Moore of the Political Science Department at Richland campus of Dallas College. Hello, Professor. How are you doing?
Hello, I'm doing great. That's the first time I've ever actually heard anyone say the Richland campus of Dallas College. I've seen it in print, but I've never heard it said until there. So it sounds a little bit odd, but I guess I'll get used to it.
I wrote it down so I could remember it.
Yeah. Well, everything's going great. How are you, Mike?
Oh, I'm doing fine. I mean,
Good.
circumstances,
All right.
everything is
In the middle of the pandemic. Okay,
Yeah.
let's get to it. What do we got?
Yeah, let's talk about some of the recent Supreme Court cases. I understand there was one about the LGBTQ community. Why don't you tell us about that one?
Yeah, there were actually a couple of cases that were combined. And again, I'm sorry, the weed whacker outside the window. I can't do anything about that. I hope you can still hear me. The court had two cases that they consolidated. One from a gay woman, a lesbian who was fired when her employer found out that she was a lesbian, and another one from a transgender woman whose employer fired her when he found out that she was transgendered. And the Civil Rights Act of 1964 bars discrimination in employment and public accommodations on the basis of a number of categories: race, ethnicity, and sex among them. Well, sex has been a really transformed concept over the last few decades. And there have been a number of attempts to amend the Civil Rights Act of 1964 so that it would include explicitly the language sexual orientation or sexual orientation and transgender. But those attempts have failed. So the advocates for equal protection, non-discrimination against gays and lesbians and transgender citizens had okay, you obviously can hear that as well as I can. Anyway, there's a legal theory, a sort of a workaround that advocates for non-discrimination against people on the basis of sexual orientation and transgender have tried to establish over the last few years. They've argued that sex really, or that sexual orientation discrimination is really sex discrimination. So the idea is that if I were a man and I were dating a woman or married to a woman, then no one would think twice about it. But if I'm a man and I marry a man, then what I've done is violate the sex stereotype. And so that what that means is under this theory is that discrimination on the basis of sexual orientation is really no more than discrimination on the basis of lack of adherence to the gender or the sex stereotype, and therefore it is sex discrimination. And so sexual orientation discrimination and transgender discrimination should be all tied up in the larger idea of sex discrimination. Well, the court had never heard a case where this argument was made directly. Now, that argument had been made numerous times at the lower courts, but it never made it to the Supreme Court, and it finally did make it to the court in these two cases. And the court, in a decision written by Neil Gorsuch, who's one of President Trump's appointees, they decided that this new conception, or this broader, I guess I should say, conception of sex discrimination is the correct one. And because what people are being discriminated against on the basis of is, yes, their sexual orientation, but it is the fact that the thing that about that produces the discrimination is that those people who are the subjects of discrimination, the people who are discriminated against, are violating the norm, the sex stereotype. And so that's what the decision was. And so it is, as of now, illegal to discriminate in employment on the basis of sexual orientation or gender identity. And so employers can no longer fire anyone for being gay or lesbian or transgender, the same as they can't fire anyone for being black or for being a woman or for being a Muslim or because religion was one of those categories. And so that just brings those people into the employment discrimination regime. Now, that doesn't cover all areas of discrimination on the basis of sexual orientation or gender identity. It doesn't cover, for example, the Masterpiece Bake Shop case, where the producer of the wedding cakes refused to bake a wedding cake for the gay couple. That's not an employment discrimination matter, so it was not covered by this decision. But it was still, in the eyes of the LGBTQ community, a huge step forward, because at least now they say discrimination in employment is illegal.
Right. Very good. Let's move on to another case. One about Texas mail-in ballots. What can you tell us about that one?
Right. Well, the court didn't decide a lot. What the court did was refuse to consider a case that was brought to them and refused to uphold a stay. So we have a pandemic going on. COVID-19, people are dying. Texas is a huge hotspot. Texas is probably not but given Florida and Arizona and Texas, probably one of the three hotspots in the whole world today for the pandemic. Well, the Texas Democratic Party had filed a lawsuit to force the Texas election officials to consider fear of contracting COVID-19 as a disability under Texas law. Let me read you, if I can find it. I've got it here on my screen. Oops. So Texas law says, well, there it is. Let's see here. A qualified voter is eligible for early voting by mail if the voter has a sickness or physical condition that prevents the voter from appearing at the polling place on election day without the likelihood of needing personal assistance or of injuring the voter's health. So the law says a qualified voter is eligible for early voting by mail if the voter has a fear of injuring his or her health. And so that is the definition of disability in Texas law. And so the Texas Democratic Party said what that means is fear of injuring your health includes fear of being forced physically to go to the polling place and stand in a line to vote and be around all those people and contracting the disease. Well, the state of Texas contested that definition of disability. They're saying disability means disability. You're more traditionally disabled. And so that was the argument. And the Texas government said that this broader definition that the Texas Democratic Party had sued to have enforced was wrong. Well, they went to the federal district court, and the federal district court found in favor of the Texas Democratic Party. Texas government appealed that decision to the Fifth Circuit Court of Appeals, and the Fifth Circuit stayed or delayed implementation of that decision by the district court, saying they wanted to hear full arguments in this case and try to decide it finally. But they said, for now, the Fifth Circuit Court of Appeals said, for now at least, the definition will be considered to be the state of Texas definition, because we are going to delay implementation of the district court judge's opinion, which agreed with the Democrats. And so the Democrats appealed that, and the Supreme Court declined to lift the stay that had been put on the decision by the Fifth Circuit Court of Appeals. So what the Supreme Court did was say, we are going to just hold off for now. We're going to allow the Fifth Circuit to go back and do a full rehearing of this case. But for the time being, the big question for the Democrats was, will the Supreme Court re-implement the delay on implementation that was put on by the Fifth Circuit Court of Appeals, or will they allow the district court's interpretation to control while it's being heard? So the Supreme Court agreed with the Fifth Circuit Court of Appeals. So right now, there are a couple of things I need to say. One is that for now, officially, the state of Texas government's definition of disability applies. So if you are not theoretically supposed to claim that you have a disability based on fear of injuring your health because of the pandemic. On the other hand, the court did say that determination of whether you are disabled is entirely up to the voter. And on the form where you request the mail-in ballot, it's just a checkbox that says, I'm disabled under this law. And if you check that, then you will get a mail-in ballot and mail it in. And then if the state of Texas wants to come back and prosecute you for that, then they're hoping that the fear of prosecution will keep people from doing that. But there's nothing that there's no pre-screening that anybody does. It's up to you. And so, if a million people say, and there could easily be a million people say, check the mail-in box, check the disability box on the mail-in ballot request. How many of those people is the state going to be able to prosecute? Not very many. So, if you don't want to go to vote in person, if you want a mail-in ballot, then you can do that. But you're kind of rolling the dice that you're not going to be the 1 in a million person who gets prosecuted for it. Yeah, now, I'll say this. I'm sorry?
Yeah, I had wondered about that. I had watched Angela Lee's interview with a representative from the League of Women Voters, who was talking about that, checking the box, and
right.
And you addressed the key question there is, well, is it honest for basically a healthy person, just because of fear of COVID, to check that box? But it sounds from your, what you read of the actual law, my understanding of it would be, sure.
Sure.
Makes a disability. So yeah.
It makes sense to me. There's one other part of it that I didn't say that I should have, and that is that this is the disability waiver, or the disability provision. It's also true that if you're 65 years old, then you are legally authorized to request a mail-in ballot. So anybody who's 65 can do that anyway. Now, I'm 63, so I'm not legal on that score, but over 60 is the heightened risk category for contracting COVID, or for having a serious response to the COVID virus should you acquire it, should you catch it. And so if you're in one of those high risk groups, it seems to me that you would have a particularly good argument. But I don't understand why. One of the things that is important about this to remember is that President Trump is spending a lot of time talking about how mail-in ballots are rampant with fraud. and mail-in ballots are the way that the Democrats are trying to rig the election. You know, it feels a little bit partisan to say what I'm about to say, but it's really not. It's just an objective statement of fact. That is nonsense. Mail-in ballots have been used exclusively by 5 or 7 states. There are half of the states, and I made that number up, some very large number of states have no restrictions on who can request mail-in ballots. Numerous states have decided in this election to simply mail a mail-in ballot to every eligible voter in the state. And those are not just blue states, those are red states as well. The idea that somehow mail-in ballots are going to be a source of fraud is nonsense. We have got lots and lots of experience with mail-in ballots in America, and there is no evidence that mail-in ballots are any more subject to fraud than in-person voting. And that's just a fact. And, you know, if it sounds partisan to be contradicting the president like that, then I'm sorry. But it is simply a fact. And we know that because of years, decades of experience in numerous states all over the country where mail-in ballots have been the primary method of voting with no fraud happening. And so you can't argue, you can't honestly argue based on facts and data that mail-in ballots are a danger of increasing the fraud in an election. I'm sorry, you just can't.
Right, right. Well, it looks like we've run out of time.
Already?
Yeah, thanks for appearing here on Spotlight On, presentation of richlandstudentmedia.com. I'm Mike Sokolski. Thanks.
And I'm Patrick Moore. Thank you very much.